introduction I will make of him. And then Alyssa and I will manage to collect names of folks who would like to, in the chat, introduce questions. And then literally, if you have your cameras on, I can keep track of you. But we'd love to be able to open it up to give you voices. I see my wonderful co-director of the Economic and Social Rights Group, Prakash Kashwan, and our fabulous director of the Global Health and Human Rights Program, Sarah Willen. And we are deeply grateful to have this incredible audience. Alyssa was giving us a sense. We have engineers, lawyers, public health experts, environmental justice experts. So this is one of the most broad-ranging audience. We have some undergraduates and some phenomenal graduate students writing dissertations that intersect with these themes, and then plenty of faculty. So we could not be more pleased. I think we have people in multiple parts of the world and multiple time zones. So if you are awake with us from India or someplace else, thank you. Thank you for joining us. We're thrilled to have you here. When you do ask a question, please don't be shy about introducing yourself with a really brief introduction as to where you're coming from. That will help Michael in terms of pitching his response to engage some of what you're saying substantively, but also the community that you represent or the perspective that you bring. Let me give people a really quick background on Michael, and then I'm going to turn over to have him speak to us for about 20 to 40 minutes. And then we'll open up really robustly for discussion. So Michael Ashley Stein is a co-founder and the executive director of Harvard University's the law school's project on disability, and he has been a visiting professor at Harvard Law since 2005. He has been a long-term friend of the Human Rights Institute here and contributor to many kind of intellectual projects and dialogues here. He's one of the leading experts on disability globally, and it was really instrumental to the development of the Convention on Rights of People with Disabilities and multiple other United Nations spaces and mechanisms. He's authored more books and articles than I can ever hope to list. He has a wonderful website, and all of those materials are available to you. And he has been the recipient of extraordinary awards from, again, many more places than I could list. But one of the exciting things for me is that he is one of the most open and responsive. A number of you students know he's already been in touch with you prior to this event. And so with an incredibly generous heart, I open the floor for Michael.
Well, it's a great, great pleasure to be here. It's taken a while for us to do this, for which I apologize. It was just life. But many years of friendship with the Institute, with Professor Hertel, with the Economic Social Rights Group. I'm just very, very happy to be here. And everyone who is watching now or later, you're always welcome to come to the HPOD website, hpod.org, look at events, join our events, look at resources and other good fun stuff. The abstract that you may have seen is a little bit of a tease. I'll talk about disability social rights in theory and in practice. But I'm going to focus mostly on employment. And the reason for that is that the Disability Social Rights book is several years late, as opposed to various other books. Yours, Susan Randolph, contributed to it and did a wonderful job on international development. But my head is into employment at the moment, not just because I've been studying it for 30-something years, but because there's several writing projects that I'm working on at the moment. So I hope that is of interest to you, but I'll end by speaking more broadly about social rights. I'm also going to do something a little bit different, which is actually use notes. I don't normally do so, but again, there were about 3 or 4 different pieces that I wanted to put together in order to do a kind of coherent talk for you. So first, the overview. Persons with disabilities historically have experienced high levels of social exclusion across all aspects of society. Inequality in employment is particularly damaging because having a livelihood, as we all know, is immediately essential to avoiding or reducing poverty, as well as multi-generation poverty. And income can in turn create opportunities to access a wide range of human rights. The OECD, for example, in its study of the late 2000s, looked at the employment rate of persons with disabilities and pegged it at roughly 40% in its countries, compared to about 75% for those without disabilities. And in low and middle income countries, the employment rates were even lower. Here in the US, we've been hovering between the 75 and 80% unemployment rate for at least 5 or 6 decades. So we in the US have failed dramatically in that respect. Moreover, employed workers with a disability, according to the World Bank, get paid less on average than non-disabled peers doing the same work. And research in the UK has determined that the wage gap cannot be explained by differences in productivity or in human capital. Not a surprise for those of us who work in the employment discrimination field. Discrimination is, of course, compounded by other areas, such as career advancement. There are many reasons why people with disabilities fare poorly in the labor market. Some have to do with inequitable access to resources that instrumentally and disparately affect their ability to work. These include access to education, transportation, and literally the workplace itself. In addition, discrimination is absolutely rampant. A Harvard study, for example, of over 2 million implicit association tests found that disability and age, and the two of those categories actually overlap in many instances, are among the top reasons for implicit bias. These surpass gender and race or ethnicity. There is also what we call second generation employment discrimination that we can talk about in the Q&A if you like. Employers, moreover, tend to overestimate the productivity of workers without disabilities, underestimate the productivity of workers with disabilities, overestimate the cost of reasonable accommodation, and seem unaware of public policies and programs that are designed to address potential challenges. This is a toxic mix, and it results in reactions varying from outright exclusion to an outright desire not to hire workers with disabilities, to offering wages that don't acknowledge their net marginal productivity. Internalizing this stigma, persons with disabilities may also limit the investment they make in their own human capital and/or their interactions with the labor market. In addition, and depending upon what state, and when I say state, I'm really talking about country, lower disability employment rates can also result from well-intentioned but poorly designed policies that provide income for persons with disabilities, but only if they don't work, or that are designed with other disincentives to employment, for example, forfeiting one's healthcare coverage. Exhibit number 1 in that regard is the United States, although the ACA has made small inroads in the opposite direction. International human rights law references a right to work in many places. Notably, the United Nations Convention on the Rights of Persons with Disabilities, CRPD, whose negotiation I was privileged to have been involved in, includes a long and unequivocal article on the promotion, advancement, and protection of employment. We'll come to that a little bit later. Yet, despite these guarantees that are contained in Article 27, as well as selected legislation passed on disability in individual states, both before and after the treaty, there remains a great deal of work to be done to achieve equality in employment globally. By the way, I send you to the World Policy Data Analysis Center at UCLA if you'd like to see large maps that look at not only employment, but many other social rights, not only disability, but also other fields, gender, for example, and map out where there are things like paid work, paid leave, and so forth. So it's not surprising that given these centuries, if not millennia, of prejudice and paternalism that result in exclusion, that we have a challenge. To be effective, both domestic and international disability rights have to adopt what we call a disability human rights paradigm, one that is exemplified by the CRPD, one that combines civil and political rights on the one hand with anti-discrimination legislation, and the full spectrum of social, cultural, and economic measures on the other hand. This sort of holistic agenda accounts for factors normally outside of civil rights laws, like we have here in the US, which explains why the ADA is not working, and ensures that individuals can flourish and participate in their societies. So now the theory, the importance of work. The right to work, again, comes as no surprise, and its value should come as no surprise. It's recognized internationally as one of the most fundamental social rights. Indeed, it seems that in today's society, especially as we are wrestling with COVID and other issues, it is hard to overstate the importance of work, both instrumentally and socially. and many claim that work is critical to survival and the ability to live a dignified life. This claim is not difficult to accept. Work not only enables access to resources that cover basic needs, such as food, clean water, clothing, and shelter, it also greatly impacts the enjoyment of other rights like health and education. When freely chosen, it contributes to one's personal development, sense of identity, and feelings of fulfillment. Moreover, the lack of meaningful employment can greatly limit a person's ability to participate fully in social, political, and economic life, both within their communities and in their countries more broadly. As Vicky Schultz once succinctly put it, work is critical to the formation of personal identity, to the creation of communities, and to the prospect of united and equal citizenry. And here we should also recall, when we talk about citizenship, the absolutely seminal and brilliant work of the late Judith Shklar. The claim as to the importance of work holds equally true to persons with disabilities as for any other subgroup, maybe even more. Through work, persons with disabilities can contribute their skills to society and develop a sense of belonging and inclusion. However, given the degree of social marginalization and stigma that's generally faced by those with disabilities, work may in fact be even more important as a way of breaking down social barriers. Relevant here is what we call in the US the contact hypothesis from social science, although really it originates in footnote 11 of the Brown v. Board of Ed decision and the brief that was submitted there, which states that intergroup contact in the workplace will reduce prejudice and intergroup hostility in a wider society. And what's interesting is we have books about contact hypothesis, including by Cindy Estlund, who's now at NYU, and her book, which is exceptional otherwise, does not have the D word. Disability doesn't appear in it. And so it begs the issue of what happened to people with disabilities. Work forces people to interact with and rely on others that they wouldn't normally come into contact with, whether for reasons of personal bias or societal structural exclusion. And so to extend this thesis to persons with disabilities, work is a mechanism to reduce stigma, break down barriers, and help the group fully participate in society. How would we frame the right to work? Well, this is a very existing and well-known literature, so I won't spend too much time on it. But it's important to notice that the right to work is highly contentious and not all readily accept its status as a right in practice, hence the importance of the economic social rights group. One of the main issues taken with the right to work is its vague and imprecise meaning. While there may be agreement on the core goal of the right to ensure that every willing person is able to support themselves and provide a livelihood for their families or households, what actually is required by the state to achieve this goal is very far from settled. Does the right entail only negative obligations like we have in the US that's traditionally associated with civil political rights and require that states refrain from interfering with the liberties of citizens? Does it extend, as some libertarians would claim, to the right for employers and corporations not to have their rights interfered with? Or does it instead impose positive obligations commonly associated with social rights and require that states take measures to guarantee work for all of its citizens? Personally, I tend towards the latter of those two. These questions come to the very heart of the debate surrounding the content of the right to work. In fact, they go to the controversy surrounding social rights in general, the discussion of which often triggers deeply submerged but sincerely held differences between reasonable people, as the Joint Committee on Human Rights put it. How far must the state go to ensure that its citizens have work? The answer to this question appears to differ according to the kind of moral reasoning philosophers use to ground their theses of the right to work, and the disagreement that comes out of them, which has led to the fracturing of the content to work into three subcomponents: liberty, welfare, and fairness. And I'm probably not being fair in giving short shrift to these arguments. The liberty component is grounded in appeals to freedom, focusing on the individual's right to pursue her choice of employment free from discrimination or unjustified restrictions, and seems to be only negative obligations on the state. When it's grounded in the value of human welfare, on the other hand, we get a different picture, and the focus becomes on the importance of receiving an income rather than on choosing what work you do. This component requires the state to ensure that everyone in society receives some form of income, or what is known as a welfare component. Though some also understand it to be more of a protection against unemployment, and some believe it nowadays to also include an idea of a minimum wage or minimum substance, social welfare substance for everyone. It's also grounded in appeals to fairness, ensuring that conditions of employment are favorable and productive. Although this last part is largely uncontested, critics argue that the first two are inconsistent and unable to combine into a single right. How can states simultaneously ensure that everyone in society has a job while also respecting their free choice of employment? Moreover, the critics argue that if the right is to include positive obligations on states, such as an obligation to provide employment to all who wish to be employed, the right becomes too costly for many low and middle income countries to implement. And as such, it fails the feasibility stage of justification. Therefore, they argue that only the liberty aspect can be involved. The feasibility critique against the right to work is no different to the usual objection made, frankly, against all social rights. And it has been addressed extensively in the literature using these standard sort of rebuttals. And Collins, of course, goes to this in quite at length. Two of these rebuttals, we believe, are especially relevant to the specific situation of people with disabilities. First is that positive obligations flowing from the right do not ask states to go beyond their means. Rather, they're required to do what's within their budgetary constraints, also known as progressive realization. This is something that is quite common to pretty much all of Article 2 of the International Covenant on Social Rights. The second rebuttal relates to the kind of work that's guaranteed, and this raises interesting questions. Is it a right to meaningful work, or will any job suffice? It seems that the critics assume that the work provided must be meaningful in some way, whereas question, could it be that we just mean any sort of work that meets with the idea of minimal standards and that don't have greater aspirations than that? These are excellent questions, and I don't know that I have the answers to them now. But what it does is raise questions that I see all the time. The flourishing, should all people flourish to the best of their talents and the best of their abilities, versus expediency. Is it enough just to have a job? Certainly it's meaningful and life-changing for many. Is it any job, or is it towards the job of most talent usage? We see this all the time in practice. We see it especially in the area of quotas. And the question that always revolves in my mind with a guilty conscience is the perfect the enemy of the good? Framing the right to work for people with disabilities. Turning to the content and context of people with disabilities, the question arises how moral arguments underlying the right to work respond to their needs. What we're presently concerned with is how this intersection of human rights and disability theory affects the concept and development of the right to work as applied to people with disabilities. Reading through the literature at the moment, I think my favorite take on this is by Einat Albin, who wrote in 2015 in a volume on the right to work. Ironically, about 2 years ago, she was living upstairs from me, and we never quite got around to discussing this, although now we do on email. So her work provides a useful example of how these two layers can be combined, human rights and disability rights, to form a conception of a right to work. What she does is she combines Martha Nussbaum's capabilities theory with critical disability studies, including the social model of disability within it. And in parentheses, I would say, I actually would like to go beyond the social model, which is very much limited in practice, not in its scope, but in practice, to civil political rights, and move to a human rights model. But nevertheless, the social model, which is very useful, was developed in contrast to a medical model of disability, and basically has as its framework assumption that disability is a social construct. In other words, the limitations in functioning and participation in society experienced by the group are caused by contingent and remedial conditions rather than inherent biological conditions. By stressing society's role in constructing disability, the social model shifts responsibility over to society to rectify disability-based exclusion. This, by the way, although not in Albin's work, references a very strong theme within the philosophical literature of difference versus deficit, put forward very strongly by Sabanesco and Buchanan on the one hand, and by Barnes and others on the other. Nussbaum's capabilities theory, which builds on Amartya Sen's development of freedom arguments, which are much more dense and to me, in some ways, much more interesting, was developed in response to Rawls's contract, social contract, not including various members of society. P.S., not to diss Martha, but one solution to Rawls is simply to include those members of society not included who are behind the veil, which is what some philosophers tend to argue. But Nussbaum posits that instead citizens in a just society are tied together with a justice, with love of justice and compassion for those less fortunate, and that in order to lead a dignified life, as she calls it, a life with or worthy of human dignity, states have to provide funding and agency within 10 central capabilities. She's got a list of 10. And each of these citizens has to reach the appropriate threshold level. That a society that neglects one of them has shortchanged its citizens, her words, and is a failure of justice in the shortchanging. I agree with all of that, although I also note that a critical shortcoming of Nussbaum's scheme is that because she is an Aristotelian, she excludes certain individuals with intellectual disabilities from being able to achieve one of the 10 capabilities, and that is rationality, and therefore are not part of her scheme. I think that is a fatal flaw within her arguments. I also find it somewhat distasteful. For Albin, the critical link between the right to work for persons with disabilities and capabilities theory is the treatment of people who are considered economically unproductive by society, i.e., they do not generate a net marginal product, but the question is, how do we measure that? This is important because the productive members, right, those who actually can work and be productive, whatever that means, raise much easier questions. Although again, it begs the question of what do we mean by measured against? Do we mean total state outputs and costs? How much is the state otherwise spending on the group versus how much they're bringing back in taxes and other productivity? How do you do a cost-benefit analysis of it? I've tried it in various places. It is extremely complex, and quite frankly, I think the only group that can do that is the World Bank, and to date they have declined to do that. So depending upon the metric, and we can talk about policies and efficiencies in Q&A if you like, there is some point at which the disabled community while working will be inefficient, however we measure that. And the question is, how devoted is a particular nation to disability-rated employment rates? You know, how willing are they to direct resources in pursuit of having people in work because of either economic benefits or other social meaningfully benefits? Good question. However, acknowledging that resource limitations are real, the related question and the harder one is, how much has a state chosen to support other less fundamental programming, and how much are they committed to disability social inclusion? Here, Albin draws mainly on the wonderful Tom Shakespeare's work within the field of critical disability studies. And she concludes that the right to work requires society to envelop people with disabilities who stay fully or partially outside the world of paid work, while also critically considering the reasons they remain outside the labor market and the full social construct. She then looks and pushes the same conclusion by noting that not everyone in society can be economically productive, that productivity should not exclude all of them, and that there are other values by having people in the workplace. And I agree with that. Albin also argues that drawing on disability studies as in Shakespeare and capability theory as in Nussbaum, the principles underlying the right to work become clear. I don't think they were actually clear, and goes some way to addressing the main criticisms that have plagued the development of the right to work. She points out that most people in society, in fact, face some kind of socially constructed limitation. Absolutely right. The insights gained from critical disability studies can help us look at the wider population as such. So what does this mean in practice? I won't drag you through the international covenants or the ILO conventions and others, but I will note that in reviewing this whole body of work, aside from the CRPD, My colleague and co-author Paul Harper asserts in his book, Ableism at Work, that each of those statutes and measures contain hierarchies of impairment, meaning that people like me, those with physical disabilities, who don't otherwise require accommodations, are superbly favored as against those with psychosocial or intellectual disabilities. And he's right, both in formal legal practice and in the real world. The CRPD, which we'll return to now, and Article 27, if we were to read it, and I'm not going to put it on screen share, is clearly focused on a free and open labor market. And while at the UN during its negotiations, it was very striking how the discourse and the dialogue all were framed in a way that those who profess neoclassical ideas of a labor market would fully agree with. Everything about it is about the free and open market, which is a great aspiration. But it also on purpose doesn't disclose or discuss things like quotas. The word quotas doesn't appear in it. It also does not use or discuss the idea of sheltered workshops, which is something else we can talk about during the Q&A. Instead, it's directed towards the open and free labor market, which has never been open or free, protects against abuses and exploitation within the market, prevents all kinds of discrimination, and then includes positive measures that can be included within state obligations towards the right to work. And these include a whole laundry list ranging from vocational training, habilitation and rehabilitation, employment services, quota regimes, although they're not named by name, self-employment initiatives, partially reserved occupations, preferential contracts. Chris McCrudden has a marvelous book and an article on government procurement contracts that I think is brilliant about how to use that as a human rights lever. Positive cultural attitudes, collaborations with non-state actors, trial employment, assistance and supported employment, vocational guidance, technical advice, financial assistance, transportation levies, and tax concessions. We can talk about any or all of those. So now for, I think, what is perhaps hopefully the more interesting stuff. What is the theory and where does it go? Can disability rights help social rights more generally? Until now, we've been talking about what can disability rights take from social rights and the right to work. Now let's turn it around the other way. Disability rights claims, which are brought under domestic or regional law using the CRPD and when it makes sense, the International Covenant on Social Rights, can provide an avenue for challenging structural and systemic violations of social rights, including employment, but also extending to housing, food, work, education, social security, and healthcare. There is a potential here for claims, including those expressed through strategic litigation, and I'm one of those lawyers who does it, but also says we shouldn't rely on it, to fuse disability discrimination and social rights claims together and to directly target structural nature of exclusionary practices that contribute to the marginalization of the group. In most legal systems, apertures exist for bringing social rights claims, whether they're based on direct invocation of social rights or indirectly building on established case law relating to equality and other civil and political rights claims. Individual equality and reasonable accommodation claims, which sometimes fail to challenge the social construct of people with disabilities as needy and less able, can be reframed as systemic challenges to unjustifiable government decisions that create these needs by ignoring the circumstances of people with disabilities in the first place. They do so when priorities are assigned or not assigned, when programs are designed or not designed, and when decisions are rendered. In isolation, the reasonable accommodation model runs up against many limitations. Is it reasonable? Is it unreasonable? Does it create an undue hardship? In contrast, linking accommodation claims to social rights arguments opens up the possibility of targeting structural changes. And the provisions of the CRPD seem to provide a clear basis, in my opinion anyway, for the development of such an integrated disability social rights approach. As the reasonableness standard is clarified in a growing body of social rights and disability jurisprudence, in parentheses, How does it interact with the notion of progressive realization, close parentheses? It provides a manageable judicial standard on the basis of which social programs, policies, and resource allocations can be assessed for compliance with progressive realization requirements. Such an integrated approach can be developed through strategic litigation, through advocacy for compliance within the international human rights treaty systems, and linked to political campaigning. Thus, for example, legal challenges to discrimination in the employment field have been accompanied by political campaigning directed towards expanding existing programs to address structural unemployment among people with disabilities. In the same way, legal challenges to discriminatory benefit programs that deny adequate benefits can also be linked to demands for broader programmatic reform of social programs to create an adequate standard of living. Linking equality claims to wider substantive social rights claims in line with what the CRPD envisions could help to ensure that in jurisdictions lacking explicit legal protections of social rights, that positive remedies will be legitimately demanded and implemented as effective remedies to structural discrimination and inequality. In short, I think that it creates a much broader and richer way of viewing social rights. So, for example, if we think about how the way that homelessness is criminalized and stigmatized, and look at the way that people with psychosocial disabilities and other disabilities are subjected to homelessness and to lack of housing, all of a sudden we seem to have a richer way of making this argument and of proffering social rights effects. The compound effects, for example, of poverty, homelessness, and disability, and their lead to incarceration are no less seen within the area of race, gender, and other areas. And therefore, disability intersects and provides a kind of integrated approach, I think, to the ways of asserting a number of social rights arguments. There are a bunch of critical challenges. One of them, if we're beginning with the disability realm, is that often there is a tension between individual rights and assertions and remedies, and that of group rights and individuals and remedies. We have seen some cases that have leapt over that distinction. If we were to look at the Autism Europe versus France litigation, where instead of 1 or 2 children, it became a case of systemic reform of France's treatment of children with autism. If we look at the Paraguay intervention in the Inter-American area, we see that initial claim on behalf of 2 teenagers became a systemic reformation of the whole Paraguayan mental health system. If we were to look pre-CRPD at the most marvelous case to have come from Africa, and maybe the most marvelous case to my mind in disability jurisprudence, Purohit versus the Gambia, we see that a claim for one individual not receiving mental health care became an argument for reforming the entire social system, not only of mental health in the Gambia, but also of the inclusion of people with disabilities in that context. So linking individual actions to systemic violations, whether through the European Social Charter, as we just saw in Autism Europe, whether in the sort of amparo and tutela actions in many American decisions, like, for example, what we saw in Colombia, where individualized and systemic failures to accommodate individual intellectual disabilities in the education system was looked at, or the Treatment Action Campaign case in South Africa, or the Eldridge case in Canada. Seems to me a way of leaning forward and combining and learning from disability and pushing it out towards other social rights. Looking forward, and then again, we'll have a lot of very wonderful discussion on this. What do I see that's interesting or challenging? In the immediate moment, and it's occupying more and more of my work, as I know it is for many of my colleagues, COVID has made us look at telecommuting. Is it a silver lining? I was interviewed by some newspaper or other, and I said that now, after COVID, it will be much harder for employers to say that being physically present is an essential job function, and therefore people with disabilities ought not to telecommute. They can't say that with a straight face anymore. But is that a silver lining? We also have some pushback against it. Remember, Bush the one's first thing that he did in office was the New Freedom Initiative. And one of the aspects of that was to have ITC, information technology, communication, and telecommuting be the focus of it. And therefore, they wanted to give out computers at low interest loans. That was when we still had interest rates to people with disabilities. But those were people with disabilities who hadn't been educated for those jobs and didn't have those jobs. And so is it kind of a false assumption? When I was called up by the White House and invited to come and comment on the New Freedom Initiative, they asked me what I thought. I mentioned this, and then I was disinvited. So we never had that conversation. Looking further ahead, artificial intelligence, which both drives us crazy when you're left on the telephone with something that doesn't recognize your voice, but which also makes lots of things much easier. We're told, depending upon who you believe, that in 20 years from now, 800 million jobs around the world will be lost because they'll be taken up by AI. We also are told that there'll be roughly another billion people living in the world and competing for jobs. What happens to people with disabilities and the right to work in that circumstance? In a positive way, we're seeing the CRPD committee, the one that is tasked with monitoring the treaty, pushing social rights, but perhaps not enough. They're very uneven. They have gone out of the way to raise the idea of WASH, right? Clean water and sanitation, even if sanitation is not itself included in the CRPD. And we have seen that nearly all special social rights progressive implementation issues, according to this treaty and according to the members, and I know most of them and I have over their existence, and I adore many of them, but I haven't seen a right they didn't consider to be an immediately remedial civil political right. And many of them I view as progressively implemented social rights. And in this way, I think they think that they're forwarding a stronger rights regime. But I wonder about that if we're not taking the social rights seriously and implementing social rights as they are intended to be implemented. Positively, the special rapporteurs, especially over the last 7 or 8 years within the UN system, many of them have gone out of their way to include disability for the first time in their reports and on social rights. I'm thinking about the SR for extreme poverty. And here I'm speaking of Magdalena Sepulveda, and not Philip Alston, who I love, but whose recent report on poverty didn't really include people with disabilities. Reports on housing, reports on violence against women, reports on employment, and so on. They've gone out of the way to include disability. And so we're seeing a little bit more cachet and a little bit more recognition of it. I wonder about the Business and Human Rights Treaty, and I've been writing on it recently. It's a big unknown. Multinational corporations have the ability to change employment rates for people with disabilities in a way that the UN, individual states, even regional states, even the ILO have not and cannot do. And yet the current zero draft doesn't mention disability. Disability is in theory included under the omnibus other status, and disability is in theory included because the zero draft begins by acknowledging all 9 core human rights treaties from the UN, including the CRPD, but people with disabilities are not specifically mentioned. And multinational corporations have the potential to do so much. Finally, and ending on a very positive note, the big elephant in the room and the big driver of change within the world is the World Bank, with whom I've had a love-hate relationship for about 15 years. I say this as I go and on their behalf review some of Saudi Arabia's policies. The World Bank has changed their environmental safeguards frameworks to now include disability. And by the year 2030, in theory, all their operations will include disability. Right now, they're at about 7% roughly, as far as including disability within their programming. By the year 2030, in theory, that should be across all their programming. And by environmental safeguards, we mean that when 180 to $200 billion for development funds go through the World Bank every year, their operations people will have to review each of these requests and programs and see if they are not only discriminating against people with disabilities, but whether they're affirmatively taking account of them. They do that now in the realms of environment, gender, race, indigenous status, and now we'll have to do it within disability. Do they do it perfectly? Absolutely not. Is there over and under inclusion in that 7% figure, which is their own self-evaluation? Absolutely, and I could tell you stories about it. But as we see from the US in a much smaller context of being able to get about in the world under Title III of the ADA, public accommodations and goods with services, the way you change the world is through this dramatic development effect. And so being able to view in the future $200 billion or so a year of being inclusive of, or at least acknowledging people with disabilities, and having, by the way, the right to go to an inspection panel and contest exclusion from it, I think is an enormously, enormously positive development. So those are my remarks and my thoughts. I hope they were interesting, if it may be coherent. And I would love to take your questions and answers and dialogue with you. Thank you for having me.
Wonderful. Thank you, Michael. You've given us an immense amount, and I would love to welcome folks, if you would like to turn on your cameras just so that I can facilitate a little bit better. If you raise a hand, Alyssa and I will watch the chat. But if we wanted to have people open with questions on any part of Michael's talk, he's given us an immense amount, both theoretically and empirically, to consider. I would love to invite folks. And again, as you speak and introduce yourself to Michael and the rest of the group, just acknowledge where you're coming from within either UConn or other communities would be very helpful to all of us. So I will be happy to take with my trusty pencil just a little manual list. Alyssa will keep watching the chat. I'll start with Corrine. If 2 or 3 people want to raise hands, then I will know the order: Corrine, Juliet, and Laura. Let's start with those 3. And then we will take a next round. All right, Corrine.
Hi, I'm Corrine Tagliana. I teach human rights and run the human rights minor at Utica College. So thank you so much for this wonderful talk. I was so thrilled that I got to actually participate. Like, that is sort of a silver lining of COVID, is that I didn't actually have to be in Connecticut to be able to come to this wonderful talk. Given the projection of fewer jobs and more people in the world, and this sort of constant tension of, does it have to be meaningful work? What happens if we don't even have jobs? It really suggests to me that one of the strongest ways that disability rights could benefit social rights overall is strengthening that push for delinking employment and an adequate standard of living. Is that something that you're seeing going on in the disability rights movement? Because I see things, from different economic and social rights groups where it's like work should be not, instead of being necessary to have an adequate standard of living, work should be one way to provide yourself with an adequate standard of living, but that standard is guaranteed regardless.
Well, that's a wonderfully difficult and terrific question. And I'll just preface it by saying that employment, of all the social rights that I look at and all the areas in policy that I work on, I've worked in 44 countries, literally on the ground, and in more virtually. It's the one area that I'm the most pessimistic and not bouncy and happy about, because in 30 years of studying it, I haven't seen any progress. But if we're talking about, the right to work and about linking or delinking with minimum standards, the best thing that I've seen lately was, and I had a little bit to do with it, was the government of Israel doing 2 things. One is they increased the disability benefit, and it's not quite there yet because they did it in stages, to be equivalent to the minimum wage, so that there's at least some decent or not super harmful safety net. And then secondly, which they're not done with yet, is thinking through at what point you never lose those benefits, and at what point does the tax system jump in? So how do you do the magic whereby people are incentivized to work and therefore be part of society and and their labor is worth more than their effort. But also at one point, is it fair to start to tax them? They're thinking it through on a level and with a nuance that we don't and others don't, because their Ministry of Social Insurance, which is my translation of it, has the data, because it's a small place, to actually say, well, if you live in X, you actually have greater costs than if you live in Y. We don't do that here. So, people in rural Oklahoma are getting the same benefits as those in downtown New York City, if anyone does live in downtown New York City, which is where I'm from. So I can joke about that. The problem with your question, which is a good question, is that it works a lot better for middle and high income countries when we talk about a minimum standard than it does for low income countries. And in parentheses, I point out that all resource restraints are real, but all resource restraints are also subject to politics. So we're a very high income country. And there's some things that we have found worth trillions of dollars, like invading the Near East, whereas other things like having a basic school system or having children not starve are not. So they're always based on politics, but they are real at some level, close parentheses. How do you handle it? I think we are at some point moving towards some kind of a basic income or some sort of a basic substance. Not in this country, because even a moderately fair staggered tax system is attacked as socialism. So I don't know that that's going to happen here very soon, but perhaps we'll see it in other places. If we can decouple disability from the specialized social welfare benefit and instead attach it to a larger political scheme, I think the group is better off. So if it's not just about disabled people, but if it's about everyone having a basic standard of living, then I think we do good. In the same way, to look at something else, if accessible public transportation is good for everyone, then it's not you wind up with a much broader political support for it.
Thank you, Michael. Let me take Juliet, and then we'll jump to Laura, and then we'll take another round.
Thank you so much. I am completely thrilled about this conversation and how in depth you went in so many areas. One, I'm coming at this from the point of view of an event planner at UConn. You spoke about flourishing. It brought a question to mind. How do we create an environment for flourishing in an online event? How do we do that for all attendees? How can we think like an attendee who has a disability? And would there be language that we would put on our registration pages that are beyond? We do have a slot now for people who are registering for an online conference to suggest or share things that they would like the planner to know.
Well, you ask, I'll answer it in the event context and then more broadly. And this is after years of banging my head against the wall at a certain university to the north of you. Universities and lots of other places are currently in the US in the compliance world. And their feelings are that people with disabilities are kind of a pain, but we got to deal with them. And therefore, we have to comply with them. And so we'll do what we need to do because it's right and just, and we don't want to get sued. Although when some of us, universities do get sued, they don't exactly, shall we say, put their best face forward. But the trick is, and I wrote about this in Disability Disclosed, if you want to look it up online, is that how do you move to the not the compliance and tolerance stage, but in the gosh, I look at the world, and if I don't see X number or Y number or certain sorts of people, I just don't feel like it's a full world. You belong. You're not only welcomed, but you belong. Our good disability compliance people over at Harvard have started encouraging and putting signs on things such as people with disabilities are welcome to these events. We want to ensure your participation and, and empowerment or something like that. I think I wrote the language. So if you need a reasonable accommodation in order to better fully participate, please let us know, et cetera. And that seems to be well. But universities, which can be agents of change, and I wrote on this with Paul Harper, still have not pivoted from the we tolerate you, we'll accommodate you, towards gosh, we want you. And if I'm wearing my lawyer's hat, every single university that I know of gets federal money in one form or another. And if they get $1 or more of federal money, they're under obligations for Section 504 of the Rehabilitation Act, which say not only can they not discriminate, but they must use affirmative action. Well, most universities I go around, maybe it's me, I'm not overwhelmed by the number of faculty, staff, students, and visitors with disabilities. So, we talk about legal compliance. We don't even have that. But creating a sense of belonging and welcoming, which is rough.
Yes. Thank you. I want to pass the voice to Laura and also thank Laura because Laura had pointed out, and then we'll grab Prakash, that we're taping and we'll make sure that this is captioned in the tape that's provided. So thank you to Laura, and Laura, take the floor.
Hi, so thanks so much. I'm Laura Walton. I'm associate professor in women's studies here at UConn. And I have a two-part question, and it kind of builds on both of the questions that have already been asked, actually. So it feels kind of nice to sort of bring some things together, I wonder. And the first part has to do with the notion of the right to work and strategies within human rights, because I'm not working in the field of human rights. So this is sort of an outsider's question about what human rights is trying to do with regard to promoting access to work while at the same time questioning and critiquing the equivalency of work and productivity with social worth. So are there parallel tracks happening, I suppose I'm asking, around problematizing the idea that people need to be quote unquote productive to be worth something? As we know, that is rooted in eugenics, that capitalism, ableism, all of that is what creates that that logic in the first place. So I'm wondering if there's both the parallel tracks of access to work if you want it, but also critiques of those equivalencies. And then my second question was about, I was going to circle back to this event because it's not captioned. So this is something where we've already excluded people. And captions are good for everybody for lots of reasons. And part of it is the ubiquity of Zoom. And it doesn't have this like basic feature that lots of other platforms or some other platforms have. But I was thinking about, again, this is sort of an outsider's question about human rights. When people are talking about access and accommodation, those legal terms, as you mentioned, are usually linked to burden, like, oh, this is such a, such a burden we have to accommodate, right? I'm wondering if people are setting up access as generative, access as expansive, access as creating a broader public, so that if we, like you mentioned before, having an accessible transportation system, that's great. Then more people can use it. More people can participate in social life. So I guess I'm wondering if people are talking about access more broadly as something that is generative and good for all. And I wonder if this might be back to how disability rights contributes to social rights more broadly speaking. And just that, I guess part of it has to do with our as when we plan events and when we make these spaces to do that work. I have spent hours on the phone with UConn, about trying to get things captioned for my classes, because I don't show anything in my classes that doesn't have captions as a rule. And I get told all the time that I can't get captions unless there's a person asking for accommodations. So, I mean, so I'm thinking about access as generative and positive rather than a burden. So I know that's a lot. Sorry, I'll stop talking.
Well, they're wonderful interventions, questions, and seems to me that the link between your two different areas is, what is it that we consider to be the baseline of normalcy, desire, for policy and for inclusion? And in the first one, there's this overwhelming assertion going back to Elizabethan poor laws, that in order to contribute to society, in order not to be, one of these, undesirables, you need to generate income, net positive income. And we see it across many spheres, right? I mean, we see it across immigration and the public charge doctrine that the Trump administration brought back after its hiatus, right? And its effect upon people with disabilities. By the way, the effect on immigrants and people with disabilities who are of various, ethnic backgrounds, including Houston, which is the #1 immigrant-filled city within the U.S., has been, deplorable and just painful. So yes, we do that rather than think about work as a means and a value of itself. And some countries are wrestling with that. So, Norway, which has the opposite approach, right? Cradle to grave support. And is money coming out of its ears between natural gas and oil and other things. They're now thinking about, well, wait a minute, if people have all this support and they don't want to and don't have to work, what does that do about social isolation and connectedness? And that's especially in a country that has, high alcoholism, suicide, and so forth. So yes, linking it just to a net marginal product is part of the problem. With how they think about it. There are some countries that do, a much better job. In Japan, for a number of years, although they may have changed now, you get your disability benefit, and then whatever it is you get by working, if you do work, you work. And they have some interesting public-private distinctions. On the accommodation, again, it's baselines. We only have accommodations if we haven't built things universally designed to begin with. Right, we've created the need for accommodation because Zoom doesn't have embedded into it captioning as, say, Google Chat or others do. We need to have the modification into the building or the train or whatever it is because we didn't build them accessible to begin with. And positioning that discourse as those of us who are normal and part of the, governing elite, we have access to it. But for you, we're going to have to make some kind of accommodation. Pitching things at a universal level, winds up being so much better. And if we just pivot for a moment to employment, if we actually look at companies in the US and elsewhere that have done a decent job on disability-related employment, and there are very few, right, that actually have significant numbers on it. Those ones are the ones that are working on diversity across the board. So they're making their places welcoming and embracing of women and transgendered folks and people of different nationalities and religions, etc. And once they get that cultural of inclusion ethos in, then disability just becomes one of many, rather than it's all us normal able-bodied folks, and then there's, them.
So I'm going to ask Prakash to come next, and maybe Prakash, you can talk a bit in response. I'm burdening you as my co-chair with also fleshing out some of, and I can jump in at any point as well, with some of really the helpful things Laura laid out for, this is a very big group. There are 50 of us. Not everyone speaks human rights. And so looking at this critical perspective, I think is really, really helpful. I'm nodding to all of my human rights Gladstein committee members. That's a really important intervention. And I think Michael's doing a wonderful job, but to the extent, Prakash, maybe you want to follow on with your question and or engage some of what Laura laid out, I think is really helpful.
Thank you, Shireen. Thank you, Michael, for this really wonderful talk and all the great questions. I think Laura articulated those questions really well, and in fact, kind of anticipated one of the questions that I had, which was about linking the universal income proposals with the expectations or the hypothesis of contact theory. And so work as a means of socialization, to the extent it can be regenerative in that sense, it provides another angle. But then once you sort of make it a totalitarian kind of argument, saying you have to be working to be called a proper human being, so I think, and I think that's the the wonderful opportunity that we have in this group to have all of these different perspectives together. I don't know, Michael, if there's something else that you want to add on the question of relationship between the the universal basic income arguments versus the sort of the demand that it places, the demand and the rewards that the work in a social setting sort of brings up. The other sort of the biggest takeaway that I got from your talk is a clear focus on structural forces, both as an impediment against certain kinds of rights, but also the ways in which, for example, thinking about neoliberal economic and political systems has shaped the discussions around rights, going back to the questions of negative freedoms versus positive freedoms and so forth. And this relates to a very productive discussion we had a couple of months back on the questions of responsibility and the relationship between responsibility and rights. And I really appreciated your insights in that realm. But then I thought you also brought in the point that sometimes people who are affected by different kinds of disabilities, they internalize these hegemonic discourses that are born out of those kinds of structural forces. And I thought maybe that's a point where we have another way of thinking about what an individual can do to sort of, challenge, deal with, or overcome those kinds of processes of internalization, as opposed to making individuals responsible for what has been done to them, right? So I thought your argument about internalization may help us grapple with that question of the role of the individual as opposed to sort of making them responsible. I have a very complex set of thoughts, and I was trying to be as nice as I could be to other kinds of arguments. But I think if you get my points, I'd really appreciate some of your thoughts on that.
Well, they're wonderfully complex and interesting. On the universal basic income one, when I think about that, I actually think, yes, about people with disabilities, but I also think about unpaid work and the gender implications of it. And, the way that we value some things and don't value other things. And as some of my work is public health, nowadays looking across the state vaccine levels, right, and their plans, which are abominable in some places and puzzling in most places. There's a divide in some states between paid care workers and unpaid care workers. And sometimes this has to do with disability and sometimes it doesn't. But I think it's very telling that we value some people and we don't value others when they're in the same situation as far as public health risk and so on. Nobody really knows about the actual measurable effects of human capital disincentives to investment. I was moderating a panel the other month, I guess. And there was an Australian economist who was looking at certain effects of disablement, people who enter the job market at a certain age with a disability and those without. And then what happens if they encounter a disability and what happens to them. And he was unable to tease out, although I thought it was an interesting question to ask him about, about what it does as far as investment in human capital development. In other words, if you're 22 and you go straight to work in whatever it is, and you're disabled at 30, are you as likely as your twin who is not disabled to continue and get that extra degree? Or to take courses on management or to try for promotion, or are you unlikely to do it? I haven't seen studies on it. I think it's an amazingly interesting question. How do we get around the internalization of stigma? Part of the problem, of course, one is that we have stigma, which Hans Morgenthau, the hearts and minds of men. We can't legislate against it, and we can't make people think differently, right? Although, we can do certain things, and makes me feel old and grouchy, but I'm afraid I think the way forward is on social media and on other platforms like that, where we get to see other people and we make them less other. My late friend Paul Miller, who was a little person who worked in employment discrimination, appeared on a reality show at the beginning of these reality shows. And I asked him, I said, why on earth did you want to do that? And he said, because I can reach millions of people and show them that, I'm just like everybody else, rather than, all the work I did for years at the EEOC, or in whatever it is that I'm writing. So I think we have to deal with that. How do we get around internalization? That's tough, because we put people with disabilities, just like everyone else in marginalized groups, to the test of either, being cast by the wayside or overcompensating and being twice as good and trying to do more than. And it shouldn't be a binary. There should be somewhere in between that people can just be themselves. So I don't have a magic wand for that.
Let me grab Erica, and I want to I'm going to quickly move to my second screen and make sure I'm not missing anyone who might want to show me your face and raise your hand. At the moment, I just have Erica, and I'm mindful of the time. We're at Molly next. Okay, so Erica and then Molly.
And I'll be quick. I was trying to paste it into the chat but for whatever reason, it won't let me.
Oh,
but I'll be quick. This might be more of just a comment, but I'm thinking more about your point about flourishing versus expediency, and the question of, is it enough just to have a job and any job? And, who gets to determine, who gets to determine what is dignified and meaningful work, and how this intersects with disabilities and disability rights conversations. And I'm coming at this from a specific perspective that intersects with my work on sex work and sex workers' rights. And a lot of people, and I'm new to disability studies research, but because of my interviews, my work is leading in this direction. But a lot of my respondents said that they came to doing sex work because of all these exclusions they faced in the mainstream labor sector. And, in the inability to access the specific accommodations that they need. And in turn, they speak about sex work as a really empowering, sustainable alternative because they have flexibility and autonomy. But then there's these added complications that it's also another level of stigma, and beyond that, it's criminalized in most places. So I just think it's really exciting to think about your blending of the social rights frames and the disability rights frameworks in order to address these more structural level problems with access and inclusion, exclusion. And, I just wanted to kind of broadly throw that out there because I just thought I was like, oh, that's how we can get to that, right? So thank you.
Well, thank you for that. And thank you for having reached out and sent me your work. I don't have the answer to it. I struggle with it. So in China, if you're blind, you're highly likely to be encouraged by the CDPF, the China Disabled Persons Federation, to become a masseuse. Is that better than not being employed? I don't know. It's not, a job is a very good thing. It's not for me to tell people not to have jobs. Would we want Ray Charles or Stevie Wonder giving us massages? Well, probably if they sang. But would we want as a society, would we lose something if they did that, or if they did data entry or worked in a telephone, ordering service? Probably. But I struggle with those questions all the time. And most of what we have in the US is little pilot programs within companies, like distribution centers for
Right.
people with ID, and they use pictograms rather than written materials, or the big four accounting firms who want to hire people on the spectrum to do the same sort of stuff over and over, but then they don't get integrated into the corporation across the board, let alone move up into senior management. I can't look those people in the eye and tell them you're in violation of my human rights norms and aspirations by having a job. I think it's great that they have a job. So it's complex.
I think we're
Molly
gonna,
Land.
Molly, yes, exactly. We have Molly Land and then Vic Schachter. I saw another hand. So Molly, go right ahead.
Hi, Michael. It's nice to see you, and thank you so much for your talk. I wanted to ask a question about something you said about the social model of a disability, and I think the part of your talk that resonated most strongly was this idea of what disability might bring to social rights in terms of thinking about structural inequalities and universal design. And you said most people face a kind of socially constructed limitation, and I really appreciate this idea that thinking about things in terms of the social construction of these limitations as broadening kind of political alliances and constituencies to push for things that are more accessible right from the get-go. But I wonder if, so I'm also thinking here of like the piece, I just looked it up, it's, I'm sorry, let me look up her name, Kamari Palomil on Blackness as disability. And I just wonder if there's a potential, I'm also thinking about gender mainstreaming here. I'm just wondering if we open up the concept of disability, right, to think about socially constructed limitations and of all kinds, is there a way in which, you could risk disability being erased almost, right? So that I think about, so in gender mainstreaming, right, there's this push like gender should be a part of all of all of our discussions at the UN, and I think it ends up being that gender is not discussed. And so I wonder if there's a tension. So when I saw the piece on Blackness as disability, I was like both like, oh, that's awesome. Let's think about more things as, in this terms of social construction, but does it bring a downside? Does it bring a limitation to it of sort of erasing the concept and what it means and what it's come to mean as a political base?
The answer to that is yes, absolutely. There is a tension in disability rights between the universal approach and between the minority model approach. Right? And Sam Bagenstos has written very nicely about this, both in his book and elsewhere. There is within the minority approach the ability to have a parallel to other groups. If I'm doing an employment discrimination case, and you can fill in your own minds on whom I'm representing, what I'm arguing is that this workplace was designed in the hierarchy of white male, Christian, able-bodied, heterosexual norms as being the norm. And that when we want to inject a person with a different bodily type, faith, etc., we're accommodating and we're deviating from the norm, and therefore we're doing something different. Whereas why did we start with that to begin with? The universal approach, though, at some point winds up losing the salience of the discrimination and what sort of discrimination that we're fighting against. So, I did a piece with my lovely late friend, Anita Silvers, and Leslie Francis, who's still around, thankfully, in the Chicago Law Review on accommodating everybody. And we said, it can't just be about need, as Martha Feynman would do through her vulnerability idea, but there has to be some sort of line as to why is it about this group, or why is it about this particular right? It can't just be on need. Right? I would love, George Clooney to show up and read me bedtime stories. I have that need, but it's not a valid thing. Or to put it in less legal terms, the universal approach suffers from, what Gilbert and Sullivan pointed out. If everybody's somebody, no one's anybody. And some of the literature you refer to, Kamani is one on Blackness as disability. Craig Knopf is another on what healthcare can learn from disability. There's a very small stream of scholars who are trying to take from disability and apply it to other areas. And some people find some of it more convincing than others. I can, both of them are friends. Both of them asked me to comment on their articles. I disagreed with parts of their articles, but I tried to give them the best feedback as a good colleague on how to strengthen their articles. But it is a growing kind of popularity among some legal scholars to do that. One of your colleagues, right, whose name eludes me for the moment, wrote about how the criminal justice system should use the social model of disability. I wasn't quite convinced by the conclusions from it. I found the normative challenges interesting, but it seems to be a somewhat growing in popularity area of legal discourse.
I think we have time for Vic. You're next, and then I want to make sure that I catch after Vic. We have Vic Schachter, and then we'll catch one last question after that. So
Thanks,
Vic,
thanks, Corrine. You can hear me okay?
awesome.
Okay, great. Michael, thank you so much for your presentation. I spent 5 decades as an employment defense lawyer dealing with discrimination issues, and I've become, as I like to describe, a recovering litigator. And I started a foundation so you understand where my question is coming from, because it's a little bit outside what you have focused on. And that is that this foundation promotes the use of mediation to address human rights issues in backlog court systems everywhere from India to Eastern Europe to Brazil, wherever you can look around the world. And listening to your comments, which have been much more at a policy level, I'm curious because I've seen so many cases now coming through mediation and alternative dispute resolution as distinct from traditional litigation, coming through on access cases, discrimination cases, on an intensity like never before. And what I have seen is that the practical world that we live in as mediators of resolving these disputes and the educational benefit of bringing people together to find solutions to these problems rather than litigate them to death over years of time has been both an educationally very valuable process of making people more understanding of disability rights and social rights. And I'm curious, in your work or your view of the future resolution of these kinds of disputes, is there a role that the mediation world, going outside the litigation world, can continue to play, not only to resolve these issues one at a time, case at a time, but from a more global perspective of bringing about some very powerful, impactful results in respecting, if you will, disability and social rights?
Well, I'd mentioned strategic litigation because that's how I was thinking about this work. I'm one of those lawyers who teaches future lawyers, to write laws, and I've intervened, 20 something times at the European Court of Human Rights and so on and so forth. But I'm in principle against litigation. I find it highly, it has its use. It has its use. But, even within social rights, God help me, it's not really enforced. It makes a point and it makes a standard, but enforcing it is a difficult thing. It has a use because it's more systemic than mediation, when mediation is one-on-one, although mediation could also be systemic. And I hope at some point in the future, we'll see larger ideas, right? Rather than one grievance, but larger ideas. Hey, can we think about how we look at public health, or can we think about how we look at maternal health within this area, resolved through mediation? Nobody feels good after litigation, as you all know. And of course, the bizarre thing in our Anglo-American system of remedies and employment discrimination is that one of the remedies is you get reinstated, which is kind of like, you go through a divorce action and then the result is that you remarry. Not a great idea. I have yet to see mediation related to disability. I'm very curious on what that would look like. I think it has enormous potential. And in my fondness for mediation, I disclosed that my father-in-law is Warren Sowerby, who handles over half the high court cases in New Zealand every year. So I'm very much in favor of mediation and in non-litigious, non-bang yourself over the head. That being said, some benefits of litigation are that there is a result which is posted that others can point to. There is perhaps a little bit more leverage when it can be used, but it has all kinds of flaws, including the human flaw and what it does to people's psyches.
I would just add in one comment, and I know Shireen, time is very tight here, that in mediation, one of the benefits in contrast to litigation is it's a voluntary resolution. And we've found the self-enforcement of the parties who reach a voluntary resolution is extraordinarily powerful, where you don't need to litigate further, that the parties reach a voluntary resolution of an access problem or discrimination problem that actually has traction and works without further litigation. So it might be something worth following up on.
And we're in what now, the 40th year of the Jose P. class action, right, in New York City? I think it's the 40th year.
Mm-hmm.
Right, the kids who were part of the original class action are grown up with kids of their own.
Mm-hmm.
Michael, could I put a sort of thought experiment? And I want to come back to Laura's idea, and it ties to Vic's idea of sort of mutuality and mutual interest. When we change the notion of access and create it as an expansive construct, and I'm going to give an example because I often teach and all my students are laughing with these folksy family examples, but I have a child who had an IEP in a class because she was very gifted. And she was in a class of a low-resourced rural district with 4 boys who had IEPs for serious sensory integration issues. And this poor teacher with 21 kids, half of whom at one point had viral pneumonia, was just trying to cope. And so she decided that everyone in the class was going to do yoga, because the only way she could legitimately walk over and touch the kids with sensory integration issues in the middle of the class when she knew they were ready to bounce out of their seats was if there wasn't a sort of socialized notion of abnormality about being physically touched. And my daughter, I had no idea I was getting this good at yoga, got really mad at me one day. And she said, "Wait, Mom, I just need to do a downward dog because I have to calm down before I can talk to you." And I think what I learned in this was my child's IEP and 3 or 4 other people's IEPs on opposite ends of the learning spectrum were all changed when, as Laura says, the notion of access for everyone in the class meant developing a different lexicon for managing one's needs. So Josephine's experience as a second grader was infinitely happier because of the inclusion of 4 little guys with sensory integration, and she, who was, I don't even know what math she was doing at this point, and a teacher who realized yoga is going to be the only way that I can destigmatize the inclusion of all of these people. And I think the right to inclusion that my daughter had, or that the other 4 had, meant changing the structure, as Prakash was saying, to humanize the notion of the tactileness and the caring interlocutor of the teacher. And I use that example only because the mutuality, she talked to me as a parent of an IEP holder about this strategy. And I thought it was an extraordinary moment, whereas Vic's saying I had to buy into the idea, but I bought into it because it changed my child, it changed the experience of those 4 children, and collaterally, everyone else in the class benefited, right? All 21 of them learned yoga at the end of the day. So I leave with a happy example, but I'm just curious if it resonates at all, Michael, because instead of pitting a special kind of IEP against another kind of IEP, everybody changed because of the presence of the IEP holders for the better. So Laura's idea of access that fundamentally makes the system different, I think is really interestingly illustrated in this public school example.
Laura was right. I mean, when things are accessible to all and they become the norm, then the expectations and the notions of where the baselines are change. So for those of you who are younger or more hip than I am, which is probably everyone, and who have iPhones, you now have text to voice and voice to text because that's the normal thing. That's a disability accommodation that was injected in there originally. And now it's something that everybody uses and don't even think about as being related to disability. Same like that email thing, which is now what everybody does and uses. Same like once upon a time, a typewriter and a telephone and a jacuzzi, and we can go down the list. So when things are not, this is a disability thing, but everyone else can enjoy it, but rather here's what we all enjoy, the normalization process, the inclusion process is different. But not to end on a doer note, our brains are trained to catalog and categorize. And our anthropology is such that we recognize ourselves and others. And there still needs to be an educational effect, whether it's yoga in the classroom or elsewhere at some point, about why, it's okay to have purple hair and a nose ring, or a blue shirt or whatever it is. And that's just the way that some people tend to present themselves.
So we have less than a minute or two left, and I just want to make sure there's no one who wants to ask a final burning question. If not, I would ask only for this moment that you unmute so that Michael can hear our fulsome applause and see our faces and receive our appreciation. So thank you, really. This was an extraordinary event for me personally, but I think for all of us to be joined in something really uplifting. And if you want to hang for a few moments at the end, anybody who does, that's fine. We're going to stop officially the recording at this portion now. And Alyssa and I will work, and Laura